I'm attorney Nick Alcock. I'm going to talk a little bit about the DUI process here in Arizona. Now, obviously, every DUI case is different, and there are different levels of DUI ranging from a misdemeanor offense to a felony offense. But with regards to the traffic stop and the way that the police investigate a DUI, it's actually pretty consistent, even if it's a felony or a misdemeanor. What you need to know about DUI is that the traffic stop, usually every traffic stop at night, police officer is pulling somebody over. They're actually conducting a DUI investigation before they even contact you, before they even walk up to your car. They're looking for whether or not someone is weaving. They're looking for whether or not there is indicia that the driver is impaired by alcohol. Maybe their lights are off. Maybe when they pull into the parking space, they're pulling askew, or they're pulling into two different spaces. All that is evidence that the police officer is cataloging. There has to be reasonable suspicion to pull somebody over. A police officer just can't pull someone over for the heck of it. There has to be either a reasonable suspicion that criminal activity is afoot, or there has to be some type of civil traffic violation. And believe it or not, we actually get quite a number of DUI cases dismissed because the traffic stop in itself wasn't based on anything more than a hunch, or based on anything more than maybe an anonymous caller calling in saying, hey, I think that someone is driving drunk and they're driving a white truck. Officer pulls over a white truck. What do you know? There's not enough evidence to pull over any white truck in Maricopa County. And believe it or not, police officers make that mistake all the time. It's something that we take advantage of, and we get a lot of cases dismissed because there isn't reasonable suspicion to pull somebody over. Police officer will then approach the vehicle. Then they're looking for additional evidence, bloodshot, watery eyes, whether or not the person is fumbling for their driver's license, whether or not the person is slurring their speech, or it looks like that they're confused about where they are, what time it is. So a lot of these questions that the police officer is going to be asking really are designed to determine whether or not the person is impaired to the slightest degree by drugs or alcohol. Someone who's just nervous, hands are shaking, and they're looking for their driver's license, it takes them a little bit of time, that actually could be used against them in court. So if you are pulled over for DUI, you should have everything ready to go. You should have your driver's license, you should have your proof of insurance, hand it to the officer. You don't want to fumble around. Believe it or not, even the way that you are dressed and your appearance can really affect whether or not you get arrested for a DUI. If you're disheveled and you're not tucked in and you've got a big stain on your front of your shirt, you're much more likely to be arrested for a DUI. And disheveled, disorderly clothing is actually a box on the police report that police officers check. If they see that, they say, well, it's more likely that this person would be impaired if they look a certain way. Police officers may ask you, would you like to submit to the field sobriety test? And you can always say, no, officer, I really don't want to. And that's totally your right. At that point, the officer has to determine whether or not there's probable cause that you are driving a motor vehicle and that you are impaired by alcohol. If you haven't submitted to the field sobriety test, and if you haven't answered any questions about consuming alcohol, then your case actually might be fairly defensible because there may not be probable cause to arrest you. And this is why I tell anybody, if they're pulled over and the police officer starts asking them questions, if you haven't been drinking, still, I don't think it makes any sense to talk to a police officer until you talk to a lawyer first. And it doesn't cost you anything just to tell the police officer, I'd like to speak with an attorney before I answer any of your questions. And they understand that that's your right, and they're not going to take that personally, and they should accommodate that request. So once someone's pulled over, let's say they've submitted to the field sobriety test, they've blown into a handheld device that shows alcohol is there, they've admitted drinking alcohol, there's probably probable cause, or it's more likely than not that the person's been driving and they're impaired. However, if you're pulled over and you park your vehicle absolutely perfectly, you've got your documentation in order, your orderly appearance, you hand it over, you don't answer any questions, it's going to be hard for that police officer to arrest that person based off of that evidence alone. And one thing that certainly I would look at in a case like that is whether or not there's probable cause. From that point, then your case would go typically to a station where you would be asked to submit to a blood or breath test. If you submit to the test, then you're either going to blow into a machine or they're going to take your blood. They can make you do both. If you don't, then they're going to threaten to take your license away for a year, and then they would probably attempt to get a warrant to pull your blood forcibly if they needed to. The warrant process is so streamlined now that the vast majority of cases, the police officers are able to get a warrant. People just wind up getting their license suspended for a year, and the net effect is they get your blood anyway. There are some cases where you may not want to submit no matter what, but if you have a question about that, you can always give us a call. if they do get your blood, if you do blow into the machine, you might get cited for a DUI if you're over the legal limit, which is 0.08. However, there are two different ways that you can get charged for a DUI. One is for being over the legal limit of 0.08. The other is for being impaired to the slightest degree. So they may charge you for DUI even if they don't get a blood result, even if they don't have a breath result. If they feel like you were impaired to the slightest degree because you submitted to the field sobriety test and you stumbled a little bit, they can actually charge you for 1381A1, which is driving while impaired to the slightest degree. What that means exactly, impaired to the slightest degree, is one of those things that's basically up to the jury. I can tell you this, that many police officers will ask the question, did you feel like you were impaired or that alcohol affected you on a scale of 1 to 10, 1 being not at all, 10 being incredibly much, where are you? And people say 2. That's as if they're admitting that they were impaired to the slightest degree. So in the next section, we're going to talk about what happens in court, but that's pretty much the DUI process as far as getting pulled over to whether or not a police officer is going to arrest you. So the next section, we'll talk about what happens in court.